Good morning. Hey, great. Awesome way to start the second day. Hope you had a good rest. Thank you to Taya and Emma for leading a fascinating discussion last night. I'm really grateful for taking the lead in that important discussion. We are going to have a full day again today with keynote talks and concurrent sessions and lots of good meals and conversations. So let's get right to it. My job is to introduce our first speaker of the day, who really needs no introduction at all, but I'm going to do it anyway. So Dr. Taya Cohen is tenured associate professor of organizational behavior and business ethics at Carnegie Mellon University's Tepper School of Business and holds a courtesy appointment in the Department of Social and Decision Sciences. Her research focuses on honesty, ethical behavior, moral character, negotiation, and conflict management. She publishes her work in top management and psychology research journals and is regularly featured in many well-known media outlets, including the New York Times, the Wall Street Journal, the Financial Times, BBC, NPR, Time Magazine, and others. She has received outstanding publication awards from the International Association for Conflict Management and from the Society for Self and Identity. And in 2020, she was recognized as one of the best 40 under 40 professors. Dr. Cohen recently served as president of the International Association for Conflict Management and currently serves on the editorial board of a number of journals. Today, she will be sharing her fascinating work on honesty and lawyers. Please join me in welcoming Taya.
Thank you, Christian. Thanks. It's wonderful to be here and get to start the day today. Hopefully, you can hear me in the back. As I understand, this microphone is to the camera only. So I want to begin by kind of going back to last year and also the outset of this project. And so many of you may remember from last year and also from the white paper we wrote back in 2020 when we were starting the Honesty Project, that we were conducting a systematic review. When the Honesty Project started, Christian was saying how he didn't think much work had been done in philosophy, and I was like, how much work has been done in management, applied psychology, business ethics? So along with Emma Levine, Will Fleeson, Benny Cooper, and a doctoral student Emma has worked with Elizabeth Huppert, we conducted a big systematic review, tried to identify all the articles published in the last 20 years across 15 journals in management, business ethics, applied psychology, anything that studied honesty, dishonesty, truth, lies. Found 169 articles, read them all, and started thinking and reflecting on what do we know, how do we think about honesty. And we came up with this model, which I presented last year, a multidimensional model of honest behavior. And so I'm happy to report this article is in press. It should be out in the July issue of Academy of Management. And it's interesting sitting in the sessions yesterday and thinking about our model and how it differs from some of the others that have been presented here, like Sun Wu's respect for the right not to be deceived, and Christians. And I think one thing that's different about what we're saying here is we think honesty is much more than not lying, right? That of course, I think all of us agree that lying sort of goes against honesty, and sort of we have this idea of belief speaking with honest content. But what we're arguing here is that full honesty, whether we can reach it or not, is relational and requires fostering understanding of the truth in others, right? Through what we disclose, how we disclose it, by verifying what we're saying is true and accurate and updating our beliefs. So we have this truth-seeking element. Right? So we've talked about belief-speaking, truth-seeking, and fostering understanding of the truth in others. And so I can present this as going into this work in lawyers because this was this theoretical framework that sort of guided this current empirical project with lawyers and law students that also started a little bit after the Honesty Project. And so some background on this. Right after we received the grant funding for this project and we were thinking about honesty and how honesty is more than simply not making material misstatements, it also involves disclosure, I was contacted by a lawyer in Pittsburgh, a practicing lawyer, arbitrator, mediator, a man named Robert Creo. And he had come across my work, I don't know if it was from media or from Carnegie Mellon colleagues, and he said, I've been thinking about honesty for a long time and lawyers, and I don't know anything about research, but I have access to lawyers, and I'd love to do something. And so we started talking. It was 2020, so it's on Zoom. Right? So we were on Zoom having these meetings. I started talking to some of what I was thinking was interesting. talked about this work on paltering, which we've mentioned, using truthful statements to mislead others. And he's like, lawyers do that all the time. It's everything we do. And so we talked about all these ways we can deviate from honesty without outright lies. And kind of recognize that studying lawyers and law would be this fascinating context to study honesty, because lawyers have broad discretion in deciding how honestly to behave. But when you look at the American Bar Association rules for professional conduct, it discusses the importance of lawyers' judgments and their professional discretion in their decision making. And so I have some quotes here from the Bar Association rules, which all state judiciaries in the United States have adopted in some form as part of their regulations, pretty much completely. And so in the preamble, there's statements like, as negotiator, a lawyer seeks a result advantageous to the client, but consistent with requirements of honest dealing with others. Right, so honesty is called out. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues must be resolved through the exercise of sensitive professional and moral judgment guided by the basic principles underlying the rules. And so even though I've given this talk before to different audiences, including a group of economists in Europe a year or two ago, and they said, like, honesty among lawyers, isn't that an oxymoron? Like, we don't always think of lawyers as honest. But if you look at what's expected of lawyers, at least in the professional rules of conduct, honesty it's talked about, moral character is talked about. There's two specific rules that I think are interesting to consider and reflect on as we think about our multidimensional model of honest behavior. The first is Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. Right? So I think that's more straightforward. But there's also part of that talks about disclosure, failure to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, which is a rule governing confidentiality. And I think even just by the language of these rules, the first one is relatively straightforward. It's clear, right? Don't make false statements. And then there is this obligation to disclose sometimes, but are you going to get disbarred if you don't? There's a lot of discretion, right, that comes into play here. And that's what we wanted to look at in this research, because when people have discretion, right, that's when their character is going to potentially matter for their choices. How do they view the decisions? Right? How do they make sense of the decisions they're faced with? The other rule I'll highlight here that has to do with honesty in the rules of professional conduct is about maintaining the integrity of the profession. It's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. There's a few other clauses. But basically, there's these sort of general statements that suggest lawyers should be honest. But I think it's still not completely clear of what honesty entails. Right? So when situations like this one allow individuals discretion in their decision making, there's going to be variability in the decisions that are made. And so the classic psychology work had kind of talked about this as strong situations versus weak situations. And when you have a situation, we might think of it as a more weak situation or where it's not always clear, we can think of what's going to explain the variability. So we can look to personality, right, aspects of the person. And here I would say, the aspects of the person that is probably going to matter is their moral character. And then we can talk more about how we think about that, but the aspects of personality that relate to ethical decision making. And then how do they make sense of the decision? How do they frame the decision? Are they seeing it through more of an ethical lens, or are they seeing it in a different way? And one of the new ideas that we brought into this paper was this idea of game framing, which I'll share with you today. So moral character, I won't spend a lot of time on. I started thinking a lot about this in 2011 at the Character Project, which is also funded by Templeton and run by the Wake Forest group here, Christian and others. It's the aspect of personality that describes an individual's tendency to think, feel, and behave in an ethical or moral way. The ethical or moral behavior. It's interesting as I've gotten to know a little bit about the legal scholarship. There's actually quite a lot written about moral character. Deborah Rohde is a scholar who's written a book on this, and others, pointing out that state judiciaries insist that successful applicants to the Bar Association must possess good moral character. And there's lots of thorny questions in the legal profession about how do we define that in this high-stakes setting. Since this is a research study with sort of anonymous surveys, I'm going to sidestep that question and rely on sort of established measures from psychology, which we know can predict moral and ethical behavior. But of course, this question of how do we measure moral character, how do we think of what good moral character, that's a challenging one. But with research and sort of through our standard measures from psychology that many of us in this room have worked on for many years, we can get a pretty good sense. Yep. So when individuals have higher moral character, that's sort of this general characteristic of who they are, it's going to affect the specific decisions that they make and how do they make sense of the world. So individuals with higher moral character, they're more likely to apply what we can think of as an ethical decision frame to the decisions they're faced with. They have greater moral recognition or moral awareness. And so there's a large body of work, or some body of work about ethical decision frames. Kristen's in the room has done some of this, where people are seeing an issue or decision in terms of ethical values, principles, values like maybe caring or fairness and others, that go beyond self-interest of organizations or individuals. And one thing that's really interesting that Eric Helzer and I were reflecting on in this work is almost the entire body of research on ethical decision frames contrasts it with a business decision. It's either an ethical decision or it's a business decision. Sometimes it's an ethical decision or it's a legal decision, as if these are opposites. And Eric and I really were thinking through that, and we're like, that doesn't sit right. That means like business decisions could not be ethical, which just seemed a problem for in terms of how we were thinking about things. So then it led to this big question: what's the opposite of an ethical decision frame? If we're not seeing it through an ethical lens, how are we seeing the decision? How are we making sense of the choices we're faced with? And that led us to this idea of game framing. And the idea we have here is that game framing and ethical framing, they represent contrasting ways of making sense of the world, contrasting ways of understanding relevant norms that apply to a situation. Individuals' decisions are going to be a function of which frame they apply to their decision. And negotiation is an interesting one because some people might see negotiation as a game, right? You're going to, especially with lawyers, you might put on your lawyer uniform and this is just how I act in this context. Right, which is maybe seen as an adversarial context. My goal is to win. The rules are arbitrary. I'm just playing the game. And we kind of are thinking of this as a way in which we kind of, how do people make sense of negotiation? What are the relevant norms they're applying to? And so I'm going to unpack this idea of game framing. It draws a bit on some of the philosophy literature on games, which has been interesting to learn about. When we think of games, there's two key features I want to highlight. The first, I think, is straightforward, that most games are experienced as adversarial. Right? You think of prototypical games, there's winners and losers. It's not all games, of course, there can be cooperative games, but people are trying to achieve their goals, and the goal is to win. And so with that is going to come the implication of a strategic mindset, a competitive motivation to achieve one's goals, beat opponents. And we know from prior work in negotiation, not particularly surprising, that people who approach negotiation as a chance to be competitive and win, they may use competitive negotiation tactics. Those could be ethical, those could be unethical. And so just having this adversarial mindset or drive to win, I don't think necessarily is going to drive people towards dishonesty. And you think of the US legal system, it's an adversary system, but we could have fair play, right? And so this on its own could lead to bad behavior, but not always. But when you combine this adversarial mindset with the belief that the rules are arbitrary and artificial, that they could easily be different, that it's just a game, and it doesn't say anything about who I am as a person, I think that's sort of a recipe for dishonesty. And so game rules do not carry over outside the specific game. They could easily be different. And so I came across this book, some philosophers in the room may be familiar with this, by Suits, a book called The Grasshopper. And it talked about how moral rules are experienced as ultimate rules. Game rules are not. And this resonated with us. And also even some earlier data, we were trying to make sense of what is a moral decision and people experience as more serious. Right? There's something about that when it's just a game, games are fun, it's not real. But I think an implication of that is that there's a belief that how I behave when I'm negotiating, if I see that as a game, it's not saying anything about who I am. And so behaviors that test or cross moral boundaries can be cordoned off from negotiators' beliefs about their character and values. And so we then developed a measure of game framing that kind of has these two elements, this adversarial mindset plus a belief that how I behave in this situation doesn't say anything about who I am, that the rules are arbitrary. And so with these ideas in mind, we sort of set out with a simple study to test 3 hypotheses that kind of follow from this. The first is that individuals with higher levels of moral character will apply a game frame to negotiation to a lesser degree than those with lower levels of moral character. Honesty when negotiating will be inversely related to the degree to which individuals view negotiation through a game frame. And that honesty when negotiating will be higher when individuals have higher versus lower levels of moral character. So 3 associations. We're going to test this cross-sectionally as opposed to experimentally. So, causality is, we can't establish that, but the basic thinking, the model is moral character is more general. It's sort of this general characteristic of how you see the world, experience the world, the decisions, and then that's going to be associated with the specific lens or frame you put on specific situations like negotiation. And then if you understand that, then it can help you predict a very specific decision about whether to honestly disclose information to opposing counsel to correct their misbelief or misimpression. Right? So it goes from general to more specific is the logic. Okay. So thus far we've conducted 2 studies, the first of which is published. It was published in 2022 in Negotiation Journal, which is an outlet that's nice because it has readers who are both psychologists, business, as well as law professors, more of a specialized journal. And so we conducted a survey of 215 US lawyers in September 2020. It was a short 15-minute survey. Basically, my colleague Bob said, the lawyers are going to be bored right now with COVID. We can just send them surveys. I think they'll complete it. And I was like, OK, let's try. And so we did, using different listservs from the Bar Association. I've actually done some executive teaching with lawyers. So we had some contacts throughout the US. And we got on some listservs. And we were able to get 215 lawyers to complete a survey, all different specialty areas. And the survey had some demographic employment information about sort of the kind of law they practice. And then we had a 8-item measure of game framing. I'll show you the items to give you a sense of how we operationalize that. We wrote 3 vignettes, each of which the lawyer was faced with the decision. You know that opposing counsel is under a misimpression, a false impression. You didn't necessarily, or you didn't create that, but how willing are you to kind of move to settlement without correcting the misimpression versus how willing you would be to disclose that information, right? And so this is not about how willing or likely are you to make false statements. To me, that's a little less interesting question. People are going to agree that's wrong. Some people are do it anyway. But the real interesting question is, what are people's beliefs about how willing they would be to maybe go above and beyond, where they might technically be required to disclose the information, but it's a little less clear. And we thought there'd be variability there, and we wanted to see lawyers' beliefs about that. Okay, and of course, this is low stakes, right? It's an anonymous survey, so you'd think if anything, people might want to be more honest or see themselves as more honest. But we also looked at moral character. Here we use 3 measures that we've used in a lot of prior work. A scale on guilt proneness, which is sort of the strength of your conscience. Would you feel bad if you've done something wrong? Honesty, humility, we have a few items about that. There's sort of general personality characteristics. We've heard about that at this conference. And then we looked at moral identity in this study. So there's been a subsequent study. So after running that survey, publishing it, and I've given talks, there's a colleague I know who is formerly at Marquette University Law School, Andrea Schneider, now at Cardozo Law School, and she has been really interested in my work and saw me present this, and she's like, we have to study law students. I think law students are becoming less honest over the course of law school, and it's a really interesting framework. I think what we're teaching them to follow the letter of the law. And anyway, so she got excited. She brought Art Hinshaw, some others. Matt, who's here, started working with us. And last year, we launched a big study of law students that we hope will be a longitudinal study. So we collected the first wave, about 2,000 law students at 15 law schools from the US. And it has a similar structure, although here we have a few different categories of vignettes. So we have some new ones we wrote here for material misrepresentation, omission, which you would be required by the rules of professional conduct to disclose. And I can show you some of these. False impressions, which is similar, but you're not necessarily legally obligated to honestly disclose. And professionalism, which kind of is going above and beyond on honesty. And then in this study, we looked at negotiation, game framing, moral character, and a few other things that might be interesting, like well-being. Because I've also learned through collaborating with law professors that lawyers are very unhappy and have low well-being and suicide and alcoholism, and it just sounds miserable. So we also wanted to look at well-being here, and that's the subject of Matt's dissertation too. So we'll hopefully longitudinally be able to kind of get some insight there. For today, I'll focus on honesty, moral character, game framing across these studies. Okay, so game framing. We came up with 8 items. We wanted a short measure that captures these 2 aspects of this mindset. One, the first 4 are about these adversarial beliefs about negotiation. Right? The goal is to beat your opponent. Being cooperative is a liability. People could strongly disagree or strongly agree with these items. And then the second set, I think, is what's more novel, this idea of that the rules are arbitrary and artificial. The line between appropriate and inappropriate conduct is actually fairly arbitrary. My favorite is the last one: how a person behaves in negotiation does not reflect anything about their true character. And although we can separate these, they sort of all hang together. They're all these items are correlated with one another. And together we think this, people who are more likely to agree with these items, endorse these items, we are thinking of they're having more of a game frame of negotiation. And so when we kind of think about responses, so this is the 215 lawyers, you'll see there's a distribution. Some of the lawyers in our sample are strongly disagreeing, right? They don't not at all agree, I think was the response option we used in this study, with these items, but some are agreeing and saying, yeah, I agree quite a bit with these items, right? We're not getting 5, it is a 1 to 5 scale, so people aren't saying, completely agree, but we see variability among the. And then when we look at the larger sample with law students, we get actually a nice normal distribution here. And this study went from strongly disagree at 1 to strongly agree at 5. And so on average, we see the law students here at a little over 2. So they're not completely agreeing with these items, but there's a range. And when we have this variability, we want to see, does it track with the decisions they make in these vignettes about how willing they would be to honestly disclose information? Okay, so this is the vignettes I'll show you from the lawyer study. They're a little shorter. The first study with lawyers. This one we called The Client Can Work. And each of these 3, they were written by my colleague based on his actual experiences of his colleagues. We tried to keep them short, but in written about to be reflective of the kind of situations a lawyer might face. So during settlement talks, the opposing counsel's comments make it clear that he thinks your client, the plaintiff, has no ability to work, although you didn't make that claim in any pleadings or communications. On the contrary, plaintiff can work. And so we had then a few different items for people to kind of share their thoughts. But the focal one that we're using to operationalize honesty is here, how likely are you to continue to settlement without correcting opposing counsel's misimpression? And so here, low scores indicate more honesty. We also had some other items that we report in the paper about different ways you might disclose. And so, again, we have variation. With some lawyers in the saying, I would definitely I'd be extremely unlikely to continue to settlement without disclosing. Others are like, yeah, I'd be extremely likely to continue to settlement, which we would see as low in honesty, right? If you're moving forward without correcting this, this misimpression. There's another, it's similar.
Sorry. Does it matter what the opposing counsel thinks? Is this relevant to the case? I don't understand the implication of this. If they have a misperception about the guy's shoe size, why would I correct that?
Because he thinks the client has no ability to work, and so this is settlement talks, and so if the client can work, that's directly relevant to the case that we're making, right? So if if he can work, and then they believe he can't, that matters for the settlement. So that's the idea. Yeah, thanks for the clarification. Second vignette, this is a non-compete clause omission. And again, here, there would be an obligation to disclose, but it's you represent an at-will executive terminated from a large company without explanation. And essentially something's left out of the non-compete clause. Right? So the executive had direct communication with the CEO and orally agreed with a list of companies he would not work for, and then one of them is left off. How likely are you to continue to signatures without informing opposing counsel of the omission? And here we have many of the lawyers saying that they'd be unlikely or extremely unlikely, but some are saying that they would continue. And from what I understand from my colleagues on this is a situation where you actually should disclose. Whereas this third vignette we have, which is, I think, would be a good fodder for a TV show, but is actually based on a real case faced by a colleague of my co-author, the case of the twin brother. You're representing a client in a mediation process involving a disability claim. Following a confidential caucus the mediator has with the opposition team, the mediator is a caucus with you and your client and states that the defendant has absolute proof your client is not disabled based upon a video she's seen. You ask the mediator to leave so you can have a private caucus. You find out from your client that he has a twin brother who had come to the house to help with physical chores like landscaping, roof repair. And this question about honesty, this is in the other direction, and here you're not necessarily legally obligated to disclose this. But the question is, how likely are you to disclose information about the twin brother and his work on the house directly to the opposition team in a joint session? And we had some other questions, or how likely are you to wait and use this as a gotcha moment in court, right? A smoking gun kind of thing. And here we have variation with some, and here higher scores is more indicative of honesty. With some lawyers are saying that they would definitely disclose this, others saying that they would not. And so then the question is, how does the game framing and then questions about moral character relate to people's choices in these situations? Okay, I'm not going to talk a lot about moral character, but I have this here just to give you a sense. I'm happy to answer questions. But in this particular study, we use 4 items from the brief Hexaco, so these general items. I find it difficult to lie. I want to be famous, general items about character. Guilt proneness is a measure I developed and have used for many years. After realizing you've received too much change in a store, you decide to keep it because the sales clerk doesn't notice. What's the likelihood you would feel uncomfortable about keeping the money? And then we have moral identity, which presents people with this list of characteristics and asks people how important these are to you. We had similar in the law student survey, the same guilt proneness item here. We use the 10 items from the Hexaco 60. That, in many of the talks here at the conference, people have used these. But I'll go through that quickly just to tell you about what I think is the more interesting results here, which is that we have support for our hypotheses. And just for ease of interpretation, visualization, I've mapped these as bar graph. They're obviously continuous. But here I've mapped out the bottom quartile of the sample in terms of moral character and the top quartile. And so lawyers with higher levels of moral character, they'll apply a game frame to negotiation to a lesser degree than will lawyers with lower levels of moral character. And we see that association here. Right? The lawyers with lower moral character, that bottom quartile of the sample, are more likely to endorse those game framing items. Yeah. Honesty across all 3 of the vignettes. Among lawyers when negotiating, inversely related to the degree to which they view negotiation through the game frame. We see that as well. So lawyers with a low game framing, or that bottom quartile is what's visualized here, right? They're more likely to have honest disclosure, or less likely to continue to settlement without that disclosure. And finally, we see this moral character. Lawyers with higher moral character, they're more likely to honestly disclose information, right? Less likely to continue to settlement. Without disclosing. And we see these across the vignette. So the basic, just to recap, these are the support for the hypotheses. Moral character game framing, they play a role in determining a negotiator's likelihood of honestly sharing information. Game framing permits low levels of honesty by inducing a competitive orientation in which rules are regarded as arbitrary, artificial constructs rather than moral or ethical requirements. And so this is some initial evidence that is consistent with this idea. So that was the 2020 results. Where are we now? Well, using the data from our fall survey, the fall 2022, about 2,000 law students, we completely replicate these with different vignettes. And what's interesting is that we see that game framing and moral character actually predict across all these different categories of vignettes. And I have them in the slides. We can go over some. But basically, we had 3, each person received 1 about material misrepresentation, but how likely are you to make false statements, how willing you would be. Law students who are higher in game framing, they're more likely to misrepresentation, that there it's reversed. So low in game framing would be less likely to misrepresent. And, law students who are higher in moral character are less willing to misrepresent. But then we see it across all the other areas. So omission is something essentially left out of a contract. And there, law students are higher in moral character. They're more likely to be honest, to correct the omission. To the extent that they adopt a game frame, then they're less willing to correct the omission. And those two, the omission and misrepresentation, are situations that would be kind of relevant to that Rule 4.1, where you should be honest to be consistent with the rules of professional conduct. But the other two, false impressions and professionalism, you don't have any legal obligation to honestly disclose, but many law students, many lawyers think you should, for various reasons. That's the right thing to do. It's the kind of lawyer they want to be. It is good for your reputation, that ultimately this is good, right? There's a variety of motivations people might have. And what we see is law students with higher moral character, they're more likely to be honest, even in these situations that don't necessarily require them. The other interesting finding, which will be fascinating to see as we collect data longitudinally, but we have some evidence cross-sectionally, is that the law school class matters. And what we see, if you compare the 1Ls, the first-year law students, to the third-year law student, and you look at misrepresentation, here higher scores indicate more honesty, so reversed on misrepresentation. We see the third years are more honest than the first years. So they've learned something, maybe, in law school, right? They've taken their ethics class, and they're maybe becoming more honest. Okay? And again, this is cross-sectional, so lots of different factors, but that's sort of the idea. But what's fascinating here, and when we think of our multidimensional model of honesty, we see the exact opposite pattern for omission and false impressions, where the third years are less honest than the first years. Right? Not huge differences, but statistically significant here in that you have, if you look at the third years on omission, you'll see honesty is lower than the first years. And then false impression. Professionalism, I don't know what's happening in second year, but at least the third years seem, third years I think a little more, is more similar. But basically for omission and false impression, you see this pattern where the students are becoming less honest, potentially. Just to give you a sense in this study what these vignettes look like, because I think the omission ones, to flesh that out. You represent the owner of a cheese shop that was severely damaged during the flood. Your client closed its shop because of water damage. In your negotiation with the client's insurance company, the insurer offered to pay the full value of the business losses based on the understanding that your client was completely out of business since the flood. In fact, after the flood, your client sold cheese out of their home. Your client directs you to accept the settlement offer without mentioning the sales for their home. And my law professors who teach classes on negotiation and ethics would want to teach their students that you should not do this. But again, it's not so straightforward as making a material misrepresentation. So how likely to make the deal without disclosing the sales from the home? And it could range from very unlikely to very likely. Okay, we had 2 others similar. What's interesting to me is that this omission, it's in some ways similar to what we can think of as false impression, but here you have more discretion. The rules don't necessarily cover this. Your major client, Sahara Properties, asked you to negotiate to buy a building that has been nominated for historic landmark status. In discussions with the seller, Ozark Properties, it's clear that Ozark assumes that Sahara will pursue the historic designation, although the sales contract does not say that. Your client told you confidentially that it intends to demolish the building to construct an office building. You and your client never communicated anything to Ozark about your client's plans for the building. Ozark's attorney sends you the final sales document for your client's signature with a cover email stating, "It will be wonderful for the community when the historic status is preserved." How likely to make the deal without disclosing your client's plans for the building? Right? And so, when you think about the results, law students who are higher in moral character are less likely, they're saying they're more unlikely to make the deal without disclosing. That's the idea. Okay, let me wrap up on this part, and then I'll open up for questions and discussion. The third years were less willing to material misrepresent facts than the 1Ls, but they were more willing to omit information, allow false impressions to stand. I think it's interesting because it suggests that law school experiences, potentially, may differentially affect different facets of honesty. And this is the only study I'm aware of that shows that the same predictor, law school class, is pushing different facets of honesty in different directions, or at least it's associated with it. Right? And so other things that were a little surprising we'll explore more once we have the future ways of data collection. Contrary to expectations, game framing was lower for the 1Ls than the 2Ls or 3Ls. It didn't track with that, so that wasn't necessarily what we would expect. First years had a more adversarial view of negotiations, but there's no significant difference across law school classes in beliefs that the rules are arbitrary, artificial. And that's interesting because a lot of one popular elective in law schools is negotiation, and how that's mostly taught both in business and law schools is thinking about negotiation as problem solving. So potentially it's good that lawyers are seeing, third years are seeing it as less adversarial, but that will await some further information in the future years. Okay, I'll pause here, end here, and look forward to discussing your questions and comments. Thank you.
Let's get started off. Okay.
Thanks. That was
Put your other hands up, please.
Really interesting. So I'm almost worried that this is too obvious a worry. The takeaway is that individuals who hire moral character won't apply game frame to business.
Not as
or
much.
law, not as much. But it just seems obvious that individuals who hire moral character want to apply what you're calling a game frame to games. Right?
I don't necessarily think that has to follow. And so what makes this, when we all agree we're playing a game, we kind of understand the rules and we have agreement. We can all agree that if we're going to play a game of poker and that is going to allow for bluffing, that's acceptable. What I think makes negotiation and a lot of our work interesting is people apply different frames. And negotiation is one, well, some people, and I teaching MBA students negotiation, some are thinking like, oh, this is a game and I have to win. And others are like, no, this is serious. Like, this is our work and this is our lives. And so I don't necessarily think people who are high in moral character can't play games or can't have fun. I don't think that necessarily follows, if that's where you're.
No,
okay, I see. Okay, so yeah.
I'm saying that people who are good moral character don't apply what you're calling game frame to their actual play of games, right? They think that what matters is not just winning, but also how the game is played, good sportsmanship, cooperative. So they congratulate the winner, and the winner says good game to the person who loses, and they make one another's play better by playing well. Right? It seems to me that if you took some of what we consider to be good as opposed to bad sportsmanship in games to apply it to business or law, you'd say actually you do better as a lawyer or you do better as a business if you treated it more like the way that we think games should be.
Like good sportsmanship, is that here? Yeah. I'm not aware, maybe Christian or others, of work on a person's character and sportsmanship, but given that character affects so much of our lives, I would certainly expect that people who have high moral character in general are unlikely to be bad sports and jerks to their people on the playing field. Yeah, so I think that's consistent.
The small thing is that makes their play of the game better, right? It's not as if that's antagonistic to good playing of the game. It actually seems like if you're a good sport, then you're playing the game in the way that it should be played in your benefit.
So I hope that's true. I want that to be true because there's a question about performance. And in law, I think that's interesting because the obvious data we don't have, or the question we can't answer, is like, are people who are more honest or less likely to adopt the game frame, do they do better? And certainly my colleague who's a lawyer, he can share all these stories about situations in which he honestly disclosed something that how that sort of worked out better overall for him in the end. But it's, and I want what you say to be true, that people who are good sports play the game better and they do better. That's kind of beyond what we can say about performance, but I share the intuition that at least in the long term, people who play the game better, more fairly, better sportsmanship, that it's overall better. But other people might take a different view, that people who cheat will do better, win more Super Bowls, or something like this. Yeah, so I can't speak to it, but I hope it's true that character helps performance.
Go ahead. So in the business literature, kind of a classical piece on this is Alcatraz, his business modeling ethics,
Yep.
right? Where he explicitly says that business is a game and da-da-da-da.
Yeah.
And it seems like it took a long time for the business profession to overcome that. And I'm wondering whether there's ever been anything comparable to that in the legal literature, or do you think that the presence of an explicit ethics code in the law profession has kind of helped prevent that?
I don't know. Prior to embarking on this work, I don't have any lawyers I'm really close with or law. We don't have a law school at Carnegie Mellon, so I can't really speak to that. What I can say, though, what I have learned is it used to be the case in the model rules of conduct and other things that there was this term zealous advocacy. Some of you may have heard that. That's since been dropped. I think now it's only in like a small footnote, but it used to be, and I think certainly how law schools have trained students is this idea of zealous advocacy, essentially at the expense of all else. And that has been rolled back by the Bar Association. In terms of, advocacy is still obviously very important, but then you have these other statements that are there that I highlighted a few that are now mentioning things like honesty, and again, it's a little vague. So how it's being trained in law schools, I don't have as much of a clear sense. I'm in a business school and my background's in psychology. But from what I understand talking to colleagues, that there has been some shift away from zealous advocacy, at least that word, although there's still a legacy of that view, and I think a lot of students that may be still learning that. In business, and so I think business it's interesting. Yes, you mentioned this car article is business, like bluffing, and that has this view. I think this game frame view that at least those of us who in the room, some of us teach negotiation, and we're thinking of negotiations about problem solving and collaborative problem solving that kind of pushes against that. And so certainly been a shift, I think, in business school, at least in some ways, maybe against that, but not completely. And I think what's interesting to me about law that's a little bit different than, say, business schools is this idea of advocacy. And when you're sort of advocating for others, how then that may allow you to put your own values aside and be more dishonest because you're advocating on behalf of others. And that's true for some jobs and business professionals, but it may not be true for others.
Your answer ties into what I was going to ask about. I love the game theory. I think it's super useful. It goes beyond other things that people have done in this area. I'm wondering about the people who are low in it, and to the extent that they're experiencing this as more of an ethical dilemma between advocating for their client and being honest, versus the people who are high in game frame. I wonder if that provides this clarifying function where the path forward is more obvious to them. I don't know if you can speak to that from your data, but I wonder what you think about that idea of some people see this as a dilemma, others see it as more straightforward.
I think that's right. I'm trying to think and we have it in our supplement in the negotiation journal articles, the other questions we asked about disclosure and how you would do it, and maybe that provides some insight. But I think that's exactly right in terms of if you understand the norms are to win at all costs. How I behave doesn't matter. I think it does make it a little easier to put your own values, morals aside. And I think this is why we wanted to look at well-being in the law students, because I think that's really hard for many lawyers. And there's a lot of dissatisfaction in people moving around. And I think, to your point, once you feel your values are kind of in conflict, and this isn't what I feel like I should do, but maybe it's supporting my client, and I shouldn't, it's not clear if I should disclose, I think that does create a lot of uncertainty and a lack of clarity. And if you have this more ethical or moral frame on the decisions, and then you're trying to advocate for your client, but consistent with honest dealings with others, kind of that line, which I like, but it's like, how do you do that and then live with yourself? And then, so what happens, I think lawyers leave their jobs, or they become, and I've actually been giving lots of talks to, for like the Western Pennsylvania Mediation Council and things, a lot of them become mediators and go into alternative dispute resolution. I was talking to a woman, used to be corporate lawyer, and just so these anecdotal conversations I've had, I think this is a challenge that lawyers face, and some are able to navigate it, manage it, better than others in terms of, their beliefs about the justice system and things. But I do think it's a good point you raise about if you have a game frame, it could offer some clarity on what the norms are and how you should behave. And once that becomes uncertain, there's going to be psychological consequences of that.
Karen, is that a quick follow-up or is that in the queue?
Queue.
Okay. Alan?
Oh, thanks very much for the talk. I just wondered if you could say a little bit more about the items that were used to test for honesty that were mentioned on this slide. At one point, it seemed like we included things like, I would like to know how people make money from doing this.
Oh, yeah, that's
I want to be famous. And I got the impression that's just an established way of testing honesty, but it seemed really weird to me.
I agree.
From an outsider perspective.
I agree. And so we wanted to look at sort of these established measures of character from other work, but also keep it short. So I would not recommend these be used for bar admissions, I would say. And they're a little bit different in the two studies. And so in the lawyer survey, we used guilt proneness, honesty, humility, a brief measure of honesty, humility, and moral character. And so let me put up, here it goes. There's a Dutch researcher, Renaud de Vries, who came up with a brief Hexaco inventory. There's 4 items. It's called honesty, humility. As you see the items, they're not really about honesty, arguably. I mean, I don't know. I'm entitled to special treatment. They're sort of broadly about character. There's lots of scale validation work. They tend to track with other things about honesty, but the labeling, I agree, is not, like, I don't read, I want to be famous and think that's a measure of honesty. Moral identity is, we hear, but not with the lawyers. It presents people with these various characteristics: fair, honest, loyal, fun. I don't know. It's like a bunch of words that are moral, and then it asks people, being someone who has these characteristics is an important part of who I am. Again, it's used in a lot of prior work. The measure I like most, but I developed it, is guilt proneness. It's 5 items. I have 2 of them here. All of them have, you've done something wrong in transgression, but it's private, no one knows about it. What is the likelihood you would feel uncomfortable about keeping the money, you'd feel bad about the way you acted? It's all about your specific behavior. That tends to actually be the strongest if I would look at the patterns. To your point, specifically honesty, humility, in the law student study, we actually used the 10 items from the Hexaco 60, which are not the brief measure. These may be a little bit better. But still, it's much broader than honesty, even though that has honesty in its name. And Will has written a really nice commentary on this and about, like, these items are called honesty, humility, but it's really just, what do you call it, general benevolence or general benevolence? It's just sort of this broad character thing. In some ways, I mean, I've told some of you this in private conversations. It's interesting to me, the way I got into studying character is because it became very surprising to me that I would give people these, like, 5-item scales, and then, like, that predicts anything about people's actual behavior. In some ways, is really surprising. But then over the years, I've done all these studies with people making actual decisions for money or lying to their classmates in negotiation, or here in the lawyer study, that these general questions about would a person feel bad about their behavior if they'd done something wrong, or having a lot of money is not especially important to me. It turns out answers to those questions are associated with these behaviors. Although we do have to be really careful, I think, to your point about, even though the researchers have called them honesty, humility, it's actually quite a bit broader than that.
Follow-up, Will?
This is just about just to unplug my colleagues, because they'll tell you this afternoon about.
Yeah.
We'll return to this.
Yeah, they'll do a deep dive into this. Yeah.
Very good. Aranda?
Thanks, Taya. I really enjoyed your talk. So I have 2 questions. So when you talk about, when you introduce your theory of honesty way back to the beginning, right? Mm-hmm. It's like you define intellectual honesty in terms of, like, verifying and updating your beliefs.
Yeah, we actually have 3 components that we think about. What do we say? Seeking out information, evaluating that information for accuracy, and updating your beliefs. So we think of those are sort of the 3 kind of aspects of what we might think of as intellectual honesty. Yeah.
Right, so it's into a very expansive definition of intellectual honesty, right? It involves, like, intentionality, updating beliefs has elements of open-mindedness, so it seems like a very robust.
Yeah, and part of it, I mean, I think, and this is not an aspect of the model where we really dove into a lot, but part of it was kind of in reviewing the different literature on this and seeing the papers, like, what are the kinds of behaviors people are enacting that might be related to honesty. And the idea here is, if you're going to say something that could be true or false, what happens before that, before you make that statement? And we're thinking, well, first you have to kind of seek out some information. The level of how much you need to search for information, I think, is an open question, and then evaluate it. I mean, this came up in our discussion last night about journalism, and like if something is an opinion versus on the science page, like how much do we really have to evaluate that, and at what level is it required? I think these are really interesting questions where there's not an easy answer. And then updating of beliefs, I think, is also important. If I know that what I am saying is false, and I see photographs of the evidence that is false, but then I continue to say it, that wouldn't be dishonest. So that was the idea for this, as you point out, expansive. What are your thoughts? Because you've worked in this area.
But I feel like truth-seeking might be a better label than intellectual honesty.
Okay.
Because the truth-seeking could, intellectual honesty could simply be, I'm honest about what I know I don't know, right? So, I could tell you, I know, I don't know anything about art, for example, right? So that's being intellectual honest, for example. Whereas when you talk about intellectual honesty, it means something a lot more expansive than that, right? So commitment to getting it right in terms of your beliefs, right? So this is just a comment, right?
Yeah, that's interesting. Yeah, I think we started with truth-seeking, and then one of our big questions for the project, what is honesty in its intellectual form? So it's like intellectual honesty seems like a good label, but I take the point. And then Ryan and others here can talk about how this is similar or different to transparency. Yeah, there may be important distinctions that we're sort of glossing over.
Yeah. Second quick question. Regarding the results where it seemed like the first-year students were less honest than the third-year students, is one possible explanation the curricula at the law schools that you examined? Because it could be that maybe their curricula is somehow slightly different from other law schools. Is that one possibility, or are they pretty standardized?
No, they're certainly different, and it can be different across instructors. And the questions we have, there's a required ethics course at all law schools that usually I think is in second year, but again, it's going to vary. And then negotiation is an elective. And so we did ask people, the students, have you taken your required ethics course, and have you taken a course on negotiation? We looked at that. We thought that may matter. We also, it didn't, or at least it doesn't seem to so far. We also asked about internship experience. I think where do these beliefs, assuming things could be changing, what are the experiences? We haven't seen anything yet, but I think there's more to be done on sort of what are the people's internship experiences. We asked questions about their supervisor. And so at that point, it's still an open question, but at least having taken an ethics course yet versus not, which some of the second years had, some hadn't, wasn't associated with anything. But I think, yeah, that's the big open question. If anyone has thoughts, when January 2024 is when we want to launch the second survey, and we can change things, and that I think is the big question we want to get at, is if we were to see changes over time, longitudinally, cross-sectionally, what would be associated with those changes? Because my colleagues on this work basically think that the students are learning, basically they're learning about material misrepresentation, but even though omission which they should be relearning, they're required to disclose, it's less clear, and they're kind of becoming more, this would be fine. And I think they think they're learning really about zealous advocacy at the extent of all else. But whether we have 15 law schools, we can look at variation. It's a little hard to know what to do or what aspects of the law school curriculum may differ.
So, Ryan or Deborah, is this a quick follow-up?
No.
I'm wondering if you looked at undergrad education.
We haven't. What's your thoughts?
I don't know. I'm just wondering whether they're major. I mean, we talk about the ethics class having, but the philosophy undergrads maybe know more about ethics. And maybe
there's some earlier work, not by me, that did admit, some of you are probably familiar, that the more economics courses a person takes, the more more willing to lie, I think. And so my guess is the more economics courses a student takes, the more likely they are to adopt a game frame. One interesting conversation I had when I was doing this negotiation workshop for a group of lawyers, there was a woman who said she went to law school, I forget what school, is on the West Coast, and it's a law school known for being very collaborative, not sort of the typical culture, but she said even there, even in that environment with this culture that you'd think would be sort of the opposite, these beliefs still get inculcated in a way, and it's not clear to me why. And also I think of their jobs and their pressure, I think there's a lot of law students that go in and they want to do social justice and they have all these values about their ethics, and they go to law school and they rack up hundreds of $1,000s in debt, and then they have the corporate lawyers recruiting on campus, and these jobs seem very valuable, and then they kind of put their values aside, and even if they were philosophy majors with lots of ethical values, I think it can get crowded out. And so these are these anecdotes of people, of just lawyers talking about their experiences and what they wanted to do and then what they are doing. But I can't speak to it directly.
So, very interesting talk, thank you. And I think that the idea of the game frame is very, it's brilliant. And I was thinking, it may apply also to the scientific realm. So the fact that some colleagues apply a game frame to the, but I was thinking, one difference between us and lawyers may be, but I wanted to hear your thoughts because I'm not familiar with that word, the kind of reciprocal relationship that you establish maybe with colleagues from other companies. And I was thinking whether their behavior may be shaped by the connectedness of their social network, the stability of the links, and the fact that for some people who are more connected, a more moral, let's say, honest behavior leads to more success, and for those who are less connected, the opposite may be true.
Yeah, I love that, and I have some other work on social networks and things, so I think that's absolutely right. We can't speak to it, but so the colleague I'm working with here, he's in Pittsburgh, and practicing in Pittsburgh's a pretty small city, and that's exactly how he talks about this, and he has all these stories, right? Because the lawyers are going to be, they know each other, they're facing each other again. So there's a lot of those social dynamics, I think, in this setting as well. And when you think of why would people be honest when they don't necessarily have to, I think that's a big motivation. I absolutely agree. It occurs to, game framing applies. We talked about academic fraud, and you can think, if you think of publishing your work as a game and how you behave doesn't say anything about who you are, and the goal is to win, and the stakes are high, and the incentives are high, and and that this is what you do, this is how you be successful, then I think that's going to crowd out honesty. Yeah.
Little time and 6 people on the list, so no follow-ups at this point. Go ahead.
Actually, my question was about the things that you were talking about previously, which is in the developmental psychology literature around becoming a scientist. There are some really interesting findings with young children about the difference between I am a scientist versus I do science.
Yep.
And sort of how children persist or work when they think of scientist as an identity versus as a series of actions and behaviors that they accomplish. And I wonder if that may be where some of the developmental trends you're seeing in your law students come from. Because when you enter law school, you maybe have an idea of what it means to be a lawyer, but the purpose of a law school curriculum is to teach you how to do the behaviors of implementing the law in a variety of ways. And so I wonder if the distinctions and fine-grained ways in which you're being taught to do the law sort of crowd out maybe some ideas about what it means to be a lawyer. And that would be a fairly easy sort of identity-based questionnaire that you could give your students in the course of the 3 years to see how much they make it part of their personal brand to be a lawyer versus to do the actions of law behaviors.
I like that. And then I think the other thing that may change is this idea of what is your ideal vision of a lawyer, and then what is your actual vision? This is where we were thinking the internship. Yes, I love that literature, right? There was this prior stuff on voting, I will vote versus I am a voter. I think some of the power of sort of those subtle things has been questioned, but the basic idea has been really strong. It's interesting in terms of, I think you're right in terms of what they're learning about how to do the work is maybe to do things that allow you to abide by the letter of the law, or at least something you could get away with, even if it's not the, and so what's less certain to me, or sort of the question is, when I reflect on it, is what does it mean to be a lawyer? So say that is my identity. There is some idealized version of that, right? I'm going to defend justice and all these positive things. There's then there's I am a lawyer, and then if you look at legal dramas on TV, How to Commit Murders when I watch it, right? And just if that's your view of what lawyers are, that's going to lead you in the opposite direction. And so I don't know how law students are thinking about. Yeah, it could for sure. Yeah, I like that idea. Maybe we can have a few items. Yeah, thank you.
Yeah, so it seems to me that you could, like, there is a meta implication that dishonesty in law is bad. I don't, you're not saying that, but there's a bit of, like, that's how we feel.
That's right.
So I think, like, we should also consider that maybe these people are becoming really good lawyers by being a game framer, because the reason that this is bad is because they are defending very well the corporate evils that you have in your example. But if we have them getting black people out of, like, jail for minor offenses, or if they have them, like, fighting for, like, I don't know,
ends justify the
clean water, then it would be very good that they are just trying to win.
It's an interesting, right, what is good? So you're certainly, yeah, okay, one interesting piece of data that I think is interesting to reflect on. One of the questions we had, we didn't have a large enough sample to really test, but differences across specialty areas of law. And there's a little bit of prior work on this, not with game framing, but with a competitive conflict management style, competitive negotiation. One thing that I thought was interesting was if you look at the area of law with that's sort of highest on that, this more competitive view of negotiation, it's family law. Right? People, and that wasn't necessarily what I thought would be the case, but then you think, you're like, oh yeah, if you're hiring someone to represent you in a divorce or something, like, you want them to be the most competitive. Maybe you want them to win at all costs. That's gonna, and if you want someone fighting for justice, maybe you want them to act dishonestly to make the world better. That ends justifying the means. It gives me some concern, but I think of what's better and what's going to make a person more successful. I think you raise interesting issues, but more generally, I think is there an open question or interesting about what makes for success, and if you are a successful lawyer but you have trouble living with yourself because it conflicts with your values, I think that's part of it. Or maybe you have no problem with it at all and you're successful and you're representing clients. But I do think there's a tension, and so I take your point where, especially as an honesty researcher, I'm tending to prioritize honesty, but that's not necessarily what is best. But at least if I turn to the Bar Association rules of what they say they want, the model rules of conduct, they're saying we want lawyers who are honest and high moral character. In practice, is that a shared belief or what people think? I don't know. And certainly as a client, if you're hiring a lawyer, you may think, I don't really care about their ethics as long as they win. Right? And that's, I think, kind of in line with what you're saying. And at least some people might make that choice. Not everyone, perhaps.
One more minute. Karen, quick.
Yeah, this is related. I was wondering about how much specialty matters, like whether you get different results. I take it from the vignettes that these are mostly people working on the civil side, like litigators, or maybe not, but...
Yeah, there are half litigators and half not, and all different. Well, yeah, go ahead.
Well, because the reason I was asking is because I wonder, like, if, say, for instance, like if you're talking like prosecutors, whether they might have a view of what they're doing that's more sort of the traditional view of law as a profession, which is kind of old-fashioned now, but still has its place, where it might be, they may be thinking of it more like, say, like in medicine, right, where clinicians are going to think about their relationship to their client or their patient as a moral one already, which would make the game framing, hopefully, less likely. It'd be surprising to see that among clinicians, the game framing, even in
oh my gosh.
In situations of conflict, whether against insurance companies or pharmaceutical companies. But I don't know.
Or even the hospital systems, their employers where they work, right?
Yeah. Do prosecutors or do court-appointed guardians have the same view of what they're doing?
Yeah, it's interesting. And so we had 215 lawyers, and they're all different specialty areas. So it was not sort of didn't allow us to systematically test, because like with the family lawyers, we had 7. So, but we did have half the sample, so about 100. Did litigation as part of their work, and about 100 did not. And we did see a marginal effect where lawyers who, on game framing, so not strong, but lawyers who did more litigation had a slightly higher endorsement of game framing if they did litigation versus not. I don't want to make too much of it because it's still pretty small samples to really look at specialty. With the law students, I don't know, do we ask about specialty? I'm asking Matt, did we ask about specialty? I don't know if we did because they don't necessarily know. And I do think it's interesting though of like what they come in thinking they might want to specialize and then what they go out doing is different. But I do share the intuition. I think there's probably very different beliefs across different areas of law, and having done more talks and conversations with mediators and arbitrators, that alternative dispute resolution, which is some of our sample, I think they, in some ways, have the luxury of maybe being more honest, not having this game frame because their practice is different. They're not having to do as much advocacy because they're neutrals, and that's in some cases why they've gone into that area of law. Systematically across the specialties, I don't know, but that is the one question I have as well.
Sorry we didn't get it to everyone, but please join me in thanking Taya.
Thank you.